8, Your Lordship. My Lord, the Annexure 1 is the order of the Central Administrative Tribunal,
Page number?
page number 20. 28, Your Lordships. It's a detailed order, but then the conclusion is
What is the penalty?
the penalty is dismissal.
Dismissal.
My Lord, the charges Your Lordship will find in short in the impugned order itself. That is at page 29. Article 1 is the major charge. It appears, my Lord, is misbehaving with a senior colleague of the department lady. Subsequently, in the imputation charge, it has stated that he had grabbed her near her waist. And then the second charge is that he consumed liquor on 22nd May 2016, and that is independent of that, my Lord.
Correct. We are not appellate authority here to
Yes,
appraise the evidence and other things.
yes, my Lord. But
Question
then,
is,
but
is
there
there
are
any legal issue?
legal issues, my Lord. The inquiry officer says that he was the main that I was not given due opportunity. I was compelled to by all the persons. There the witnesses which management witnesses are contradictory in nature, and then the third is the complainant herself says that I am not ready to depose before the male member, and then the inquiry officer says
No, those are all factual aspect. I am asking you, is there any legal ground? Because the tribunal has already taken note of BC Chaturvedi case in para 9.
that is, my lord, the tribunal has taken,
No,
but then
correct. In the light of this decision,
uh,
no question of appreciation of evidence.
my lord, what I say that if I am denied of opportunity of cross-examining the complainant,
Where have you stated before the inquiring authority or
the inquiry, the report of
against the second show cause
of
notice?
course, for that I require the original record, because but in the inquiry report there is a consistency, my lord. I'll just point it out. Inquiry report I am placing, my lord, 88, page 88, my lord.
Sir, where have you taken such contention before the disciplinary authority against the second show cause notice?
And there is no
further
second
before the appellate authority and further before the central administrative tribunal.
I, I say with that in the appellate authority it is not taken.
Then we can't appreciate.
Then, my lord, one thing. The second, the rule doesn't provide that I have to be given opportunity of submission on the quantum of penalty. Yet, quantum of penalty, there is no second show cause was asked. But then,
no, where is the provision for quantum of penalty? You are entitled to notice.
There is no provision.
Then
but then considering the fact that the man was appointed in 2011, dismissed in 2016, he is at that point of time 34 years of age.
Which is relevant, sir?
Married and with two children, my lord. The capital punishment only I am saying that the penalty of
he has not been asked to hang. You can so that your contention is required to be taken into consideration that capital punishment. It is not a capital punishment. It is only a dismissal.
It amounts to the same thing, my lord, because I am on road starving, my lord.
Charges are grave, and your attitude during inquiry.
They say that, my lord, but then
shows your tendency.
Read para 8. How do you overcome? Para 8 of the tribunal.
Tribunal orders, my lord.
Yes.
It is well settled principle that the tribunal, that is 2015 volume 2, my lord.
Yes, sir.
They have stated that what is the
scope
of review, my lord. But then, my lord, in the paragraph 10, it is only just reiterating the same thing which has been stated in paragraph 8, without considering the materials on record. With reference to materials, my lord, I am saying. So it is repeating the same thing what has been stated in paragraph 8, 10, one line, everything. For each item, one line. Without referring to the inquiry report, without referring to the order of the disciplinary authority. And the disciplinary authority order is a very cryptic order, my lord. I'll just show, my lord. The appellate authority also very cryptic. After quoting the judgment, my lord, nothing has been.
My lord has asked, please show any lacuna in the order.
Oh,
If
my
you
lord,
go through the charges at page 51 and 52, so grave.
my lord, they say
And
no, there
your
are one
attitude
witness
towards
which.
inquiry is also the same. So show the lacuna
My lord,
for interference in the
one
order.
of the witnesses, management witness, in the starting he said
Naturally-
something, in the end he said something, and it has been recorded by the inquiry officer that his deposition is not inconsistent. He's
Now taking this instance of 34 years and 2 children.
yes, my lord, because I was not given any opportunity on the quantum of had
will
it
not
been.
come to his
You have
support.
worked only for 5 years. You have worked for only 5 years.
Yes, my lord, I joined
2011
in
to
2011 and 16. my
Then
lord.
where is the question of 34 years and all?
At presently he is.
What was the post held by him?
He is.
SCI executive was a, what is that? SCI executive.
Presently
Equivalent
he's.
to Milords, constable Milords.
Huh?
It's
No,
security
security-
assistant.
security
Equivalent to
assistant.
constable Milords.
Secular?
Security
Security
assistant.
assistant
Security
Milords.
assistant.
One chance to be
Constable,
given.
it's equivalent to constable Milords.
Constable.
Milords. Equivalent to constable Milords.
One chance may be given.
No
Lord.
question
Only-
of chance, sir. Anything else?
My lord, just I will place the inquiry report, my lord, just page 88, my lord.
Please give me the date of framing charge.
Yes, sir. Date of framing charge, my lord, is page 42, my lord.
It is not visible. What is the date? 13/6/2016.
13/6/2016, my lord.
What is the date of your reply?
Your reply is 68, at page 68, my lord. Sorry.
Huh?
I am sorry, just. Okay. 21/6, my lord.
21/6.
Hmm.
What is the date of inquiry report?
6/7/2016.
6/7/2000.
16. Only 5
What is the
witness.
date of show cause notice?
uh, on inquiry,
After
inquiry.
inquiry report was submitted to you for
I
seeking your
repre-
explanation.
my representation is dated 27
No, where
2016.
is the date of second show cause notice?
73, at page 73. That is the 6th July 2016, my lord.
That is inquiry report, sir. Show cause notice. Along with that, asking your explanation. You said you submitted your.
Yes, I submitted Annexure 7, my lord. That is 27 2016, my lord.
27,
2016,
20th July,
20th July,
2017 or 16?
16.
16. What is your date of your reply or representation?
Reply, date of reply I am saying, my lord.
Huh.
27 2000.
So you don't know the date of show cause notice?
इसमें आई एम सॉरी मिलोड इसमें तो पता नहीं चल रहा है.
Yes. What do you say, respondent counsel? You don't have second show cause.
Milords, Milords order, Milords dismissal. Inquiry report is Milords dated 6/7/16, Milords.
Sir, inquiry report is 4th July or 6th July 2016.
No, Milords. Inquiry report is dated 6/7/16. Reply was filed by the petitioner, Milords, 27/16.
Sir, what is the mode of communication of inquiry report to the petitioner? How did you communicate inquiry report? You people don't read the
No, no,
rules.
Millards,
Where are the rules?
This Millards, I don't find Millards in the petition, Millards.
And they,
Let me tell you, tomorrow-
in the
tomorrow,
order of
Millards.
dismissal also there is no reference. DCP authority has not applied his mind on what date show cause notice was issued.
Dates, Millards, the certain dates are mentioned, Millards, in the by the disciplinary
Sir,
authority.
show me
Millards.
from the dismissal order that on receipt of inquiring officer's report, petitioner was granted, petitioner was issued a show
Only
cause notice.
4 dates are there, Millards. I must say, Millards. Let it be Millards tomorrow,
Sir,
Millards.
these are all the principle which are
My
required
Millards,
under the rules.
Millards.
If you don't provide, how to decide the matter?
But tomorrow, Millards.
You also don't know.
No, my lord, but then
In
from
your reply, while giving your reply, with
Ah.
reference to what you have given reply.
yes, that is missing, my lord.
Alright, what is the date of representation? 20th July 2016.
Yes, 20th July 2016.
Dismissal order is 26th September 2016.
Yes. Oh, no, Millards. 4/8/16, Millards.
4/8/16.
4/8.
16.
Millards.
What is the date of
Appellate authority.
appeal?
Appeal, Millards, 22/8/16, Millards.
22.
8/16.
Uh,
And-
Rejected, Millards, on 26/9/16.
Yes.
now you want to point out something from the inquiring officer's report.
Yes, my lord. Page 88 may kindly be seen, my lord.
Page 88. Uh,
My lord, page 88, fourth hearing on 25/6/2016, my lord.
yes, sir.
On 25/6/2000, cross-examination of Mrs. Nupur Singh, Gulab Chand Singh, Avinash Lal and Deepak Kumar Sri Bablu started at around 11. At the same venue to inquire into the charges framed against Sri Gulab Chand Singh. Mrs. Nupur Singh Birpur was called and cross-examined by the inquiry committee. However, she expressed an inability to give her statement in front of any male member, and her request was accepted by the committee. She was asked whether she would reconcile or would want to take her charges back. She replied she would never take her charge back. Ms. Nupur Singh was then allowed to go, and Sri Gulab Chand Singh, Avinash Kumar, Deepak Kumar and Sri Bablu were called together for cross-examination. And then, my lord, after it appears, from the sequence it appears that the last paragraph, the inquiry officer says that Sri Gulab Chand Singh has denied all the charges leveled against him. He was also asked whether he wanted to put some question to Mrs. Nupur Singh, but he refused. So it appears, my lord, that
You have refused.
they have recorded. But then, my lord, considering the sequence
Correct.
that she has gone there, there was
Whatever
no.
it may be, why did you refuse?
Uh,
If you have insisted, then the inquiring authority would have taken necessary steps, either permitting you to cross-examine or to say that it is not appropriate to cross-examine.
Therefore, I say ki maybe there may be some misrecording, my lord. For that, original record
Sorry,
may
sir.
kindly be seen, my lord.
That's all.
And my lord, one more thing, just I am placing, my lord. Your lordship will see from the how the inquiry officer has proved the charges, my lord. From 90 case details, Article 1, then reply of CO, then points in support of charges. Okay. Then after stating the point, the CO is thus found guilty of the said charges.
What is wrong with this?
After stating that what are these points in support of charges, they
Sir, this court cannot examine all these
no,
things.
I am just placing another thing, my lord. Ki after finding that all the charges are proved, then he started analyzing, making analysis. That is at page 99. Analysis and assessment is later on. After recording the CO's objections and then analysis and assessment.
Yes, sir.
And then he has also said that no,
It may be in different format. On format you can't found fault with the inquiring officer's report.
Therefore, my lord, the assessment comes first and then the finding.
Correct. Let's
This
take
is,
the
this is my submission.
Yes.
in the instant petition, petitioner has prayed for the petitioner has upheld the order of the tribunal dated 27th November 2019, passed in OA number 050 slash 00830 slash 2016, void annexure 1. Petitioner, while working as a security assistant in the office of the subsidiary, in the office of the subsidiary director of intelligence, he was subjected to disciplinary proceedings in framing article of charges on 13/6/2016. The petitioner submitted explanation to the charge to the extent that denying the alleged charge on 21/6/2016. The disciplinary authority, dissatisfied with the petitioner's explanation, proceeded to hold an inquiry while appointing inquiring officer and a presenting officer. The inquiring officer, after holding inquiry, submitted report on 6/7/2016. On receipt of inquiring officer's report, the disciplinary authority issued a show cause notice along with the inquiring officer's report seeking the petitioner's explanation. The petitioner submitted his explanation on 20th July 2016. On receipt of petitioner's explanation to the explanation on the inquiring officer's report read with the second show cause notice, the disciplinary authority proceeded to impose the penalty of dismissal from service on 4/8/2016. Feeling aggrieved by the order of the disciplinary authority, petitioner preferred an appeal before the appellate authority and it was rejected on 27/9/2016. Thus, the petitioner preferred a original application before the Central Administrative Tribunal, Patna bench, Patna, in OA number so and so. The OA number so and so stands dismissed, while affirming the order of the disciplinary authority and appellate authority on 27/11/2019. Thus, the petitioner has presented this petition. Next part. The learned counsel for the petitioner vehemently submitted that there is a discrepancy in the finding of the inquiring officer in the inquiring proceedings. He tried to apprise this court with reference to fourth hearing dated 25/6/2016 relating to examination of one Mrs. Nupur Singh and cross-examination. In fact, perusal of the inquiring officer's report, it is evident that inquiring officer asked the petitioner as to whether he intends to pose some questions to Mrs. Nupur Singh. On the other hand, he has refused. Therefore, it is submitted that petitioner has been denied opportunity of cross-examination. Further, he has pointed out the inquiring officer, while dealing with each of the charge, has already assessed the charge with reference to material evidence. However, at the end of the inquiring officer's report, he has once again made analysis and assessment. Therefore, the inquiring officer's report is vitiated. Heard the land councils for the respect. On the other hand, land council for the respondent department resisted the aforesaid contention and submitted that there is no infirmity in the order of the tribunal, and in the result the present writ petition is liable to be dismissed while affirming the order of the tribunal. Heard the land councils for the respective parties. Undisputed facts are that the petitioner was subjected to disciplinary proceedings while framing charges on 13/6/2016. The disciplinary authority was not satisfied with the petitioner's reply on the charge memo and proceeded to appoint inquiring officer and presenting officer to hold an inquiry on the alleged charge leveled against the petitioner on 13/6/2016. The inquiring officer held that the charges leveled against the petitioner were proved. To that extent, a report was prepared and submitted to the disciplinary authority on 6/7/2016. Based on the inquiring officer's report, the disciplinary authority issued a show cause notice along with the inquiring officer's report seeking a petitioner's explanation. Petitioner submitted his explanation on 20th July 2016. Based on the records, the disciplinary authority proceeded to impose a penalty of dismissal from service on 4/8/2016. Further, it was subject matter before the appellate authority, and it was rejected on 27/9/2016. Feeling aggrieved and dissatisfied with the order of the disciplinary and appellate authority, petitioner prepared OA number so and so before the Central Administrative Tribunal, Patna bench. Central Administrative Tribunal rejected the petitioner's appeal, hence the present petition. The tribunal has examined charge memo and findings. Similarly, appellate authority order, disciplinary authority and appellate authority order were examined. The petitioner has not made out a case in terms of the Union of India and others versus P. Gunasekaran, reported in 2005 to SCC 610.
2015,
which
my lord.
has been
2015, yes.
2015.
5 is wrongly written.
In terms of the aforesaid decision, guidelines have been laid down under what circumstances court can interfere in respect of disciplinary proceedings. In terms of the aforesaid in terms of the guidelines issued by the apex court, the petitioner could not apprise this court with reference to any of the point which is required to be agitated in the matter. Similarly, question of reappreciation of evidence by the courts in respect of disciplinary proceedings. In other words, there is no provision for judicial review as held by the apex court in the case of B.C. Chowdhury versus Union of India, reported in AR 1996 SC 484. Prima facie, the petitioner has not made out a case so as to interfere with the order passed by the tribunal dated 27/11/2019. Next, we have learned counsel for the petitioner submitted that there is a discrepancy in the inquiring officer's report to his staff. Question of a discrepancy cannot be taken into consideration for the reasons that the petitioner was provided an opportunity by the inquiring officer to the extent whether is he willing to, is he intends to pose any questions to Mrs. Nupur Singh or not, for which he has refused. Therefore, question of providing cross-examination was not warranted to stop. Today, Land Counsel for the petitioner submitted that the petitioner has not been provided cross-examination of Srimati Nupur Singh to stop. The inquiring officer finding is crystal clear that petitioner refused to pose any question. In such circumstances, question of providing cross-examination to the petitioner was not warranted to his in respect of analysis and assessment of evidence on each charge is concerned, there is no infirmity except that the inquiring officer, after analyzing the each and every charge along with the evidence, further he has written a paragraph relating to analysis and assessment. Thus the aforesaid analysis and assessment in the last portion of the inquiring officer's report do not vitiate the proceedings to stop. In the light of these facts and circumstances, and there is no infirmity in the order of the tribunal dated so and so, passed in so and so, accordingly petition stand dismissed.
My lord, just quantum of penalty if your lordship feel like
No.
making observation.
Shall I record and reject that also?
Leave it, sir.
Lords, appellate authority, Lords, reaction date is 26, Lords. 26/9/16.
27/9/2016.
Appeal order 26/9/16.
26/9/2016.
My Lords.
Appellate authority order dated 26/9/2016.